realized if you've never done it before, how would you have any idea how to get divorced? And I just looked up a lawyer in the Yellow Pages, went to her office, and told her to call me when it was over. I had no idea what steps needed to be taken. I didn't even know I had divorce choices, and there was different ways of getting divorced and different processes I could have selected. Once my divorce was over, I realized that I had probably not made the best selection in the professionals to help me with my divorce, and I knew there had to be some really terrific people out there, and I just started a search of putting together the best resources I could find. Daisy Camp is for anybody thinking about in the middle of or recently divorced. People are facing situations of abuse, their addictions, alcohol, pornography. Some people are in a protective situation, but Daisy Camp helps a wide variety of people and gives them encouragement, empowerment, and knowledge to take control of their life and their divorce process. People, when they first called, all their questions are based on fear, and they're reacting on their fear. And I always have to slow them down and say, you know, do you know you have choices on the divorce process that you choose? And 90% of people or greater have no idea that there's more than one way of getting divorced. Every day is a new day to choose again. And if you have a long list of things you're going to accomplish as you work through your divorce, and you're only able to get a few things done in a day, that's okay. If you wake up in the morning and you're going to call your lawyer and you're going to make photocopies of your checking statements and you're going to work on your insurance and you only get 2 of those things done, that's okay. Or if you wake up and you decide, you know what, I can't handle this today, I'm going to put it aside until I'm feeling a little bit better, that's okay as well. But I always remind them that not to make a quick decision because they're least emotionally equipped to be making some of the biggest decisions of their life. And they need the information and the tools to be making healthy, long-term decisions. And that's what Daisy Camp is all about.
People are often interested in knowing what the best way to get started with a divorce is, and there's several levels at which we can answer that. I mean, but the main one for me is that they ought to get started, if possible, with a dialogue. They ought to be able to find somebody, either an attorney or a mediator, to have a dialogue with so they understand their options, get their information, and really try to engage in a dialogue with their spouse, either through a mediation or a 4-way meeting, which is different. The traditional way that people got started with a divorce was that somebody served papers on somebody else. And there are times in which that's necessary, but before we get to that, I really urge people to get information and to try to do a dialogue, because normally service can be avoided, and the earlier you start talking to people, the more they have a wider range. Officially, the way the process starts, if you do a collaborative mediated way, would be that you would engage attorneys and you would sit down in a 4-way meeting and sign a joint petition, which is the first document that starts the divorce. In the mediation, the process would start by the 2 of you sitting down with a mediator. Mediation is when 2 parties hire a third person, an individual or a couple typically, to work with them in resolving their issues. In a family law context, which is what we're talking about here, it's usually a divorcing couple who would typically meet with a mediator who would work with them as a neutral in a confidential setting using interest-based resolution and helping them first gather all the facts, identify all their goals, and resolve all of their issues through the mediation process. The meetings usually are somewhere between 2 and 4 hours of length. The meetings can be anywhere from 2 or 3 meetings to resolve it to 5 or 10 meetings, but the meetings are scheduled several weeks apart. In between the meetings, the parties will work on gathering information, doing their homework, as it were, and coming back to the mediation to work on issues. Mediators have a variety of backgrounds, but even if they are lawyers, they can't give legal advice. And so while mediation reduces what lawyers have to do, isn't entirely a substitute for that. So people usually in mediation, the lawyers are in the background, meaning they review things afterwards or talk to the client before the process. On occasion, lawyers are brought into the mediation process to assist in a negotiation. collaborative law is a method in which people choose collaborative lawyers who are skilled as focusing only on settlement, who agree to work only in a settlement mode with the clients. The critical difference is that the clients and the lawyers sign what's called a participation agreement, in which they agree on a variety of things, including the fact that if this matter were to go to court, the lawyers would have to withdraw. The importance of that is to keep everybody focused on settlement so that there's no danger or temptation that the lawyers are going to draw them to court. In the collaborative process, once people have signed a participation agreement, the clients and their collaborative lawyers meet through a series of four-way meetings using a similar interest-based resolution model that's used in mediation, and they work on the issues. First, they identify goals, they identify the facts that they need, they brainstorm options, and then they work towards resolution. During these meetings, again, usually 2 to 3 hours in length, probably spread out 2 or 3 weeks apart, somewhere between 2 and 3 meetings and 5 and 6 meetings, somewhere in that range. And people work towards a resolution, and then eventually the lawyers work with them to draft the documents. The primary difference is that where the lawyers would be in the background in mediation process, they would be at the table during a negotiation in a collaborative process. There are many advantages of mediation over a litigation model first, and I'll deal with that. I mean, one is that it puts the couple in charge of the outcome and of the process so that they can design a solution that's based on their needs and the needs of their family rather than having third parties make the decision. So because of that, you typically get better outcomes, or outcomes that are more lasting, generally get better protection of children, you get more control over the outcomes, more privacy and more dignity, and less expensive than the litigation option, and quicker. Now, I purposely mentioned less expensive and quicker last because even though those are true, I think the key thing in these processes is to focus on getting a better quality result. And I think mediation, as compared to typically litigation options, can allow the family to get a better result that's geared to their family. Now, contrasting mediation to collaborative law is a very similar process using the same skills and ideas. The critical difference would be that in mediation, the lawyers are more in the background and the couple sits down with a mediator, with the lawyers advising them outside the room. In collaborative law, the lawyers are in the room working in the negotiation, usually instead of a mediator. It's using 4 people in the room and a mediator not working directly with them, although there are opportunities to use both processes together, and sometimes people have a mediator and 2 collaborative lawyers. But the critical thing is the collaborative lawyers, each one represents the client, so that while the mediators are neutral, if I were a collaborative lawyer, I'd be either representing husband or wife, and while I might use a lot of the same skills as a mediator, it's clear that my job is to focus on the needs and interests of my client and to advocate for my client, although using a different style of advocacy than you would use in a courtroom. Technically, and in most states, no one's actually required to have an attorney. Most states will allow you to present all the papers and do all the work on your own. However, I typically would not advise that because almost any divorce involves complex issues which in the end are going to result in a very important agreement, so that I would recommend for people to get legal advice, but they can proceed on their own. Lawyers can represent either of the parties, but they can't represent both parties, and that's a common misconception because oftentimes one party will hire a lawyer and the other party will waive their lawyer, and that lawyer will work with the couple, and it'll seem like the lawyer is representing both. But the fact is, because there's a conflict of interest, that lawyer would be signed on representing only the wife, say, and the husband would have waived his right to an attorney, and so the lawyer is really just representing one person. The best way, I think, in terms of choosing a lawyer is that I think first an individual ought to gather as much information as they can on websites, from books, from articles, a lot of good things out there, so they come in with a base of information. The second thing is and then of course within that, ask around if you have names of people that others have recommended, if you know people who've had a divorce that went well, to find out who they've used, and then to start an interview process. And I really would recommend that they interview 2 or 3 people, because no matter how good a lawyer might be, it needs to be a good fit for them. And most lawyers will do a consultation for a fairly low amount or for free. And I think interviewing the lawyer, at least briefly, is a good way to find out how they operate and what they do. during that interview, and there are a series of questions that people should ask, and I won't cover all those here, but they should certainly find out what the lawyer's background is and what range of skills they have, things like collaborative law, mediation, and court, so that they know that this lawyer has the range of skills that fit the process that these clients want to choose. And of course, then in addition to that, ask for about hourly rates, retainer agreements, and other things that can help you sort out one lawyer from another. One of the difficulties arises when there's one party that wants a divorce and the other party doesn't want the divorce. Those are always hard cases for me, whether I'm representing the person who wants a divorce or the other party. The reality is in most states are no-fault divorce states, and so a party who wants a divorce can get one, and so there's no way to truly stop a person from getting a divorce. A few states have fault requirements, and there are ways to slow a divorce down in those states. But for the most part, if somebody wants a divorce, they're going to be able to get it whether the other party wants it or not. Because of that, the first thing we do is, of course, see whether they're willing to explore reconciliation options. And I think any responsible attorney would, in meeting with either couple, would talk to them about whether reconciliation is possible and to refer them to reconciliation sources if that's at all a possibility. If at least one party doesn't believe it is, then it's really a matter of moving forward. And it's critical to counsel the other party that at that point their choice is between doing a divorce in a way that they can have some control over, or letting it happen to them, and hopefully they'll come around to realizing that even if they didn't want the divorce, getting a divorce that they can impact and getting a divorce that allows them to achieve their other goals will be better for them, so they can work within that. I find sometimes people do actually, when through mediation or collaborative, sometimes after a few meetings, they decide they can reconcile, because part of what happens is that money gets stabilized. Sometimes there's financial stress that gets stabilized. Sometimes communication's been difficult, and if they develop some communication skills. So if in the middle of the process they decide that they want to try to reconcile, the process can be put on hold and they can work on reconciliation and decide to come back later if necessary. For a person to achieve their goals in their divorce, they need to think about 3 critical steps. The first step, I think, is getting a plan, being clear about what it is that you want to achieve, and knowing what your highest level goals are, and thinking about not just positions or immediate urgent goals, but what you want your life to look at like 5 or 10 years from now, so that you're really working on the most important things. The second thing is to get the information you need about the process choices that are most likely to get you there. So you choose a process that's designed to help you achieve those highest goals. Whether that be mediation or collaborative law or some other process. And the third piece is to find the professionals that are going to best aid you in the process that you're choosing, so you've got the right counsel and guidance in helping you focus on those goals and get the results that make the most difference. People often ask how long a divorce can take, and there's a wide range. It'll depend partly on the process they choose, partly on the state that they're in, and partly on a variety of factors, including their needs and their goals. Now, for example, my experience has been in the litigation process, most divorces ran probably somewhere between 6 months and 2 years. I mean, if somebody's going to litigate and go to trial, they have to wait for the court count, and that could be a year or 2. In a collaborative or mediation process, since there's no court involved, the schedule isn't set based on a court schedule, but really based on how long the parties can reach an agreement. Typically in these processes, I've seen averages, I would say 75% of the cases I've seen get done somewhere between 3 to 6 months or 3 to 8 months, so a much shorter time frame. But there are times in which it can take longer than that, partly by choice, either because the clients are waiting for something, waiting for a house to sell, waiting for some event in their life, sometimes waiting for reconciliation. So while it's often clients want to get done as quickly as possible, there are sometimes they choose to put it on hold or stretch it out for a while, and in those cases it can run a year or more if they want to stabilize things and do it in that way. A question I get asked a lot is how much a divorce can cost and how much it will cost using different processes, whether it's mediation, collaborative law, or litigation. And there's no clear-cut answer to that, because everybody's experience is different, and there's different studies and different things that would point things. But my experience and what I've seen, I feel pretty comfortable in giving these parameters. On one end of the schedule, if people litigate, go all the way to trial, the cost can be tens of thousands. I've seen them go over 100,000. I've heard of cases going over 200,000. There's almost no limit to what things can cost through litigation. when you look at traditional style settlements, cases that settle in the litigation process but don't go to trial, my experience was that the litigation fees were about 2 to 3 times as much as through collaboration and mediation for my own clients. And what I did is went back over the last 50 cases that were settled in a settlement context, in a court context, and the last 50 cases they settled through a collaborative process. And what I found, and even to get a range in my cases, were that the fees in the collaborative cases were right around $4,000 to $7,000 for my legal fees, and that my legal fees in the cases that we settled in someone through the court process were more in the $10,000 to $15,000 range. And there were, wide variations on that, but that was generally what the cost would be. Now, if when you compare using mediation, first of all, with collaborative law, you'd have to compare what the other lawyer would have as well. And I would assume in both the collaborative and traditional model that the other lawyer's fees were about the same as mine. So you could just double those if the question is what the total cost would be. When you're looking at mediation, as I've mediated, the legal costs go down to really a small fraction of that, but then you have to add the mediation cost to it. And when I've mediated cases, I don't have the measure of what the lawyers are spending on the legal fees, but my fees as a mediator typically run somewhere in that same range. Probably 75% of my cases when I've mediated has run somewhere between $2,000 and $5,000. How much additional money was spent on legal fees, I don't know, although it presumably was a lot less than what they would have spent if the lawyers had been more involved in the negotiation. One of the things that's important to distinguish are the 3 central models for settling cases: collaborative law, mediation, and traditional negotiation, which are really still the 3 central ways that cases get settled. As I mentioned, 95% of all cases settle, so there's about 5% that go to trial. These other 95% settle through one of these 3 methods. And to draw a clear contrast, first, to draw a contrast between traditional settlement negotiations and collaborative settlement negotiations. The primary difference is in the collaborative negotiations, the lawyers are trained in collaborative methods, which is a key piece. But the central, most important piece is that the clients and their lawyers sign a participation agreement in which the clients and the lawyers agree to abide by certain ground rules, including the fact that the lawyers cannot go to court. The difference is that changes the environment in the room because there is no threat of court and people have to focus on settlement. And the lawyers are free and the clients are free to speak more candidly because they know these lawyers anyhow won't wind up being in court, and so they can get a bit more free in their problem solving. In a traditional settlement negotiation, and there's a wide range. There are people who do traditional settlement negotiations and settle the case in one meeting. Some cases are easy to settle, so it's not as if it always goes badly, because it doesn't. But as traditional negotiations are difficult when they're done in the shadow of the courtroom, which is where most of it happens because the threat of court is there. The negotiations usually become more position-based and more entrenched, more accusatory, more argumentative, and the options often get more narrow. Some of these cases settle very early in the process after 1 or 2 hearings. Sometimes they settle a week before trial, sometimes a day before trial. But there's a different type of negotiation that goes on when people have the threat of court out there than goes on when the threat of court is removed or at least placed a bit more distance. Now, in contrasting collaborative law with mediation, is that the collaborative law process involves the primary negotiating tool are the clients and the lawyers in the same room in a 4-way meeting. In mediation, the primary negotiating tool are the clients and the mediator, and usually in a 3-way meeting if it's one mediator working on the negotiation. So if you can picture a series of meetings, 3-way meetings with a mediator, that's the core of the mediation process. If you can picture several 4-way meetings with clients and their collaborative lawyers, that's the collaborative process. A lot of the style of what goes on, interest-based resolution, different methods used in settlement are very similar, but you have different people in the room. And in mediation, the lawyers are more in the background. Collaborative law, they're more upfront and involved right at the table. And there are some situations where people use the process together, so that there are 5 people in the room, a mediator and 2 collaborative lawyers in addition to the clients.
Being nice to your spouse in the divorce process, if using a process that allows for that, is most likely to yield you very good results. I have clients who often come in and are very scared and they want me to be as aggressive as possible, and they want to be as aggressive as possible. there's a difference between being aggressive and being assertive, getting your needs met and being abusive. Sometimes people have a hard time seeing what that difference is. And so I ask them, when was the last time you got pulled over by a police officer? And we start talking about the story of what happened. Most people instinctively know that when the police officer comes, they should be as nice as they can to the police officer. And that's usually quite disarming to the police officer. On the other hand, sometimes you have people who are mad at the cop and they'll say something like, well, they were speeding and they were speeding, why did you pick me? They're probably going to get a ticket. And a lot of us have experienced this, or we've seen it in other people, that if you use kindness and respect, you're more likely to get a result that's advantageous. And when you're abusive or rude or deflecting blame, responsibility that you should be taking as your own, if you're deflecting that on someone else, it doesn't make others real eager to be trying to meet your interests for you. So when you take that into a divorce, in that divorce scenario, unfortunately, you know, when you get married and you are in a marriage for a long time, sometimes you aren't very nice to your spouse, and that's sometimes what ends up leading to a divorce. But if you can find it in you to try and be as respectful as possible during the divorce transition, your spouse is likely to behave the same way or similarly, and then you can much more quickly come to a result that's going to be good and meets everybody's needs.
A divorce decree is basically a piece of paper that is certified and signed off by a judge and all parties who are married to signify the end of their marriage. It's important to have a copy of this decree, in fact several copies of the certified decree, because you'll need it for many occasions, such as buying a home, selling a home, taking your name off credit or phone, many different reasons that we would need to see a copy of that decree. In that decree, I specifically look for things during the mortgage application to reference account numbers, to make sure that if in the credit report there is some joint debt that hasn't been solved, I can go back and look and reference on that decree to make sure that I don't have to count that as their debt because it's already been awarded or granted to someone else, given to someone else. Of course, then I would tell somebody to take that decree to the credit card company and make sure that it's off their name as well. The documentation that you should keep on hand to have for your mortgage process is as follows. First of all, I recommend a copy of the divorce decree. Some title companies will require a certified copy. Make sure you keep the staples in place, that's important. Child support or spousal maintenance. Keep copies of the checks for at least 3 consecutive months. It's important to have that even if they deposit it in your account, keep those bank statements.